from the agency and then wait up to the full 6 years allowed by current law once a permit is finally granted before ambushing good faith project developers with job-killing litigation. The Permitting Litigation Efficiency Act is short, simple, and balanced legislation to help make sure recent advances in permitting reform do not go up in smoke soon, but instead are advanced and entrenched. I look forward to our witnesses' testimony concerning my bill and the other bill we consider today, the North Texas Water Supply Security Act of 2017. That bill, introduced by Representative Sam Johnson of Texas, is consistent with my bill and highlights the need for reform to prevent the kinds of infrastructure crisis that North Texas and communities throughout the country could face without further legislation. The chair now recognizes my good friend and a ranking member from Rhode Island, Congressman Cicilline, who is, once again, our ranking member.
Thank you, Mr. Chairman. Since 1970, the National Environmental Policy Act has saved time and American taxpayers' money, while also ensuring that major federal actions that have a significant impact on the environment are safe and do not harm local communities. So whether the project is a new power plant or highway, this democratic framework ensures that concerned citizens, local businesses, and state and local governments have a voice and opportunity to be heard on the impact of federal decision-making on their community. In enacting NEPA, Congress recognized that hardworking Americans deserve to have a say in how their taxpayer dollars are being used on major projects where they live. I'm a strong advocate of making a comprehensive investment in our infrastructure, once the envy of the world, to create good-paying jobs and expand economic opportunity by rebuilding our crumbling infrastructure. But this requires a serious plan and federal resources, not a false trade-off between an investment and making projects less safe, eliminating public input, or harming local communities. There is ample nonpartisan evidence that delays in federally funded projects are due to inadequate funding, local opposition, insufficient agency resources, and project complexity, not environmental protections and safety guardrails. In 2002, the Nonpartisan Congressional Research Service reported that transportation project approval delays are not caused by NEPA. They are caused by, and I quote, project funding levels, local opposition to a project complexity, or late changes in project scope, end quote, among other factors unrelated to NEPA. Dina Baer, who oversaw NEPA as the General Counsel of the Council on Environmental Quality for over 2 decades under Republican and Democratic administrations, similarly testified that the principal cause of delay in implementing permitting are inadequate agency resources, project complexity, changes in budget, and other factors unrelated to permitting procedures or judicial review of environmental permitting decisions. Nevertheless, under the guise of streamlining the permitting process, today's hearing concerns a pair of bills that will close the courthouse doors to local citizens, public interest organizations, businesses, and local government when attempting to seek judicial review of projects of federal permitting decisions. The first of these is H.R. 4423, the North Texas Water Supply Security Act of 2017, which only applies to a single project in North Texas that has already received federal permitting approval. This bill would block judicial relief for any person who has not already commented on this permit and would dramatically narrow the statute of limitations for filing cases related to this permit from 6 years to 2 months. In addition to my substantive concerns with this bill, I'm somewhat stunned that we're considering a bill that would establish different rules for a single construction project that has already received federal approval and is not subject to any lawsuits that we're aware of. This bill also raises serious federalism concerns regarding the judicial rights of state citizens concerning their access to water, a traditional right that should concern the citizens of Texas, not the federal government. If this bill isn't a solution in search of a problem, I'm not sure what it is. The second bill we will consider is a far more sweeping proposal, the Permitting Litigation Efficiency Act, which was only introduced yesterday. This bill is designed to establish more sweeping limitations on the judicial review of permitting decisions required by law. Simply put, it would create special rules for environmental permitting projects on the Administrative Procedures Act, which Congress designed to ensure transparency, fairness, public participation, and access to justice in the regulatory system, while placing a heavy thumb on the scales of justice in favor of regulated corporations. It does so by shortening the period for judicial review of these projects from 6 years to 6 months, with limited exceptions. Second, it establishes expensive barriers to preventing the construction of a federal permitting decision by requiring as much as a $5 million bond before a person can seek an injunction of a project that requires a federal permit. This bonding requirement would apply to any party seeking a stay, including local governments, small businesses, concerned citizens, and nonprofit organizations, regardless of the merits of the case. Even worse, the bill would require costs to give this bond to defendants, regulated corporations, unless the court determines that the action was substantially justified, a standard that does not appear in current law, is not defined by the bill. And lastly, the bill, in my view, unwisely disregards the balancing test the courts have long applied to determine whether to grant injunctive relief, and instead requires courts to conduct a lengthy cost-benefit analysis of the economic effects of providing relief, a lengthy and detailed analysis that courts are ill-equipped to conduct. Notwithstanding these concerns, I certainly thank our witnesses for appearing before us today, and I look forward to hearing your testimony on these matters, and with that, I yield back.
Without objection, other members' opening statements will be made a part of the record. I will begin now by swearing in our witnesses. Before I introduce them, would you please rise, raise your right hand. Do you swear that the testimony you are about to give before this committee is the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that all the witnesses have answered in the affirmative. Please be seated. I'm going to go through and introduce each one of you, and then we'll get back to the questioning. So we'll get that out of the way. Donald Elliott is professor of law at Yale Law School and a senior counsel at Covington and Burling, LLP, and chair of the firm's environmental practice group. Prior to joining Covington, he was a partner in Wilkie, Farr, and Gallagher, LLP, chairing the firm's worldwide environment, health, and safety department. Mr. Elliott also served as assistant administrator and general counsel of the U.S. Environmental Protection Agency. Mr. Elliott also testifies frequently in Congress on environmental issues and has served as a consultant on improving the relationship of law and science to the Federal Courts Study Committee, which was chartered by Congress to make recommendations for improving the federal courts, and to the Carnegie Commission for Law, Science, and Government. Mr. Elliott is a senior fellow of the Administrative Conference of the United States and an elected member of the American College of Environmental Lawyers, as well as a member of the boards of the Environmental Law Institute, the Center for Clean Air Policy, and NYU's Institute for Policy Integrity. He is the author or co-author of 7 books and has published more than 70 articles in professional journals. He earned his BA summa cum laude and Phi Beta Kappa and his JD from Yale. Following graduation, he was a law clerk for Judge Gerard Gessel of the U.S. District Court for the District of Columbia and for Chief Judge David Bazelon of the U.S. Court of Appeals for the District of Columbia Circuit. Welcome, sir. Mr. William Kovacs is a recently retired senior policy executive with over 40 years of experience in trade associations, government, and private law practice. His most recent position was Senior Vice President for Environment, Technology, and Regulatory Affairs for the U.S. Chamber of Commerce, where he worked for 20 years and led the institution's regulatory reform efforts, including advocacy for permit streamlining legislation. His prior positions include government service as a chief counsel for the House of Representatives Subcommittee on Transportation and Commerce, Committee on Interstate and Foreign Commerce, vice chairman and chairman of the Virginia Hazardous Waste Facilities board and partnerships in several Washington, D.C. law firms. He has written many policy and law review articles and produced several nationally recognized regulatory studies. He earned a JD from the Ohio State University College of Law and a Bachelor's of Science degree from the University of Scranton, magna cum laude. And welcome to you, sir. Emily Hammond is the Glenn Earl Weston Research Professor of Law at the George Washington Law School. Professor Hammond previously taught at several universities, including Wake Forest, the University of Oklahoma College of Law, the University of Texas, Florida State University, and the University of Georgia. Professor Hammond practices law with Bondurant, did I pronounce that right? Okay. Mixon and Elmore in Atlanta, Georgia. Professor Hammond's articles have appeared in numerous top-ranked journals, and she is the co-author of one of the nation's leading energy law texts. She is an elected member of the American Law Institute, a chair-elect of the Association of American Law Schools Administrative Law Section, and a member scholar of the Center for Progressive Reform. She has served as a hearing examiner for state administrative proceedings and has provided service to the International Atomic Energy Agency. Professor Hammond earned her bachelor's degree from Virginia Tech and a JD from the University of Georgia. Welcome, Professor. Mike Rickman is the Deputy Director of the North Texas Municipal Water District and has been employed with the district since October 2002. Mr. Rickman is directly responsible for the following district departments: water, wastewater and solid waste operations, environmental services, maintenance services, and information technologies. The district was created in the 1950s to provide wholesale treated water to the areas north and east of Dallas. The district has added wastewater treatment and solid waste disposal services in its service area. The district's current service area covers approximately 2,000 square miles and continues to grow. Prior to joining the district, Mr. Rickman was employed by the City of Dallas Water Utilities Department for 33 years. Before we go any further, I'd like to recognize the chairman of the full Judiciary Committee for his opening statement, the gentleman from Virginia, Chairman Bob Goodlatte.
Thank you, Mr. Chairman. I appreciate your holding this hearing. America's voters sent the 115th Congress to Washington to do one thing above all others: help turn around this nation's struggling economy. The Judiciary Committee has been doing everything it can to fulfill that mandate, including on the regulatory reform front. In fact, with regard to the specific issue before us today, reform of America's outdated, slow-moving permitting system, the committee made a big down payment on reform during the 114th Congress, helping in the enactment of Title 41 of the Fixing America's Surface Transportation Act. FAST 41 contained the biggest permit streamlining reforms in recent years. It has already begun to clear the logjams that have stood in the way of permitting decisions for many of the nation's largest proposed construction projects. The Trump administration has been working hard to implement FAST 41 as effectively as it can. Just this week, the administration's leading permitting agencies signed a memorandum of understanding committing to even more steps to reach quicker permitting decisions, including by agreeing to meet a 2-year target for the issuance of decisions for large infrastructure projects. These reforms mean faster decisions and faster delivery of jobs and investment for projects that win a permitting green light. But there remains much work to be done. Good as it is, FAST 41 is scheduled by its own terms to sunset by 2022 unless Congress extends it. Further, FAST 41 applied only to specific categories of the largest construction projects, those involving $200 million or more in investment. Many other projects still need permit streamlining reform, and in case FAST 41 is allowed to expire, it would be best if Congress legislated permitted streamlining reform applicable to all projects before FAST 41 sunset can arrive. The Permitting Litigation Efficiency Act of 2018, of which I am proud to be an original co-sponsor, delivers precisely that reform. It establishes a strong incentive for permitting agencies to wrap up their permitting decisions for yay or for nay within 2 years. It also, like Fast 41, sets a prompt statute of limitations for lawsuits challenging those decisions, requires those suits to be based on matters actually presented to the permitting agencies during the administrative process, and assures that judges considering preliminary injunction requests in those cases will take into better account the economic potential and environmental harms of delaying project construction by injunctions. These are balanced, bipartisan, and sorely needed reforms. The second bill we consider today, the North Texas Water Supply Security Act of 2017, is consistent with them and precisely highlights the concrete need for these kinds of reforms. That's because, under existing law, opponents of the urgently needed North Texas water supply project can lie in wait for up to 6 years before suing, file suit on the basis of matters never presented to the relevant permitting agencies, and seek preliminary injunctive relief. All of that could conspire to plunge North Texans into a water crisis that could be avoided if only litigation were required to be brought in a more timely manner on the basis of matters the agencies had a chance to consider during the administrative process, as the North Texas Water Supply Security Act requires. I urge my colleagues to consider these important pieces of legislation. I look forward to the testimony of our witnesses, and I yield back the balance of my time. Thank you, Mr. Chairman.
Thank you. Each of the witnesses' written statements will be entered into the record in its entirety, and I ask that each witness summarize his or her testimony in 5 minutes or less. To help you, I think you're familiar with the lights. There'll be a green light in front of you, and when that green light switches to yellow, it indicates that you have a minute left, and when it switches to red, you have no time left. I will politely and diplomatically just sort of grab the gavel and give you a little hint that you should please try and wrap up. So please, Professor Elliott.
Thank you very much, Mr. Chairman, Mr. Ranking Member, and distinguished members of the committee. I am appearing as a private citizen, not representing anyone, but I consider myself a lifelong environmentalist, and like the Ranking Member, I'm a strong supporter of the National Environmental Policy Act. I, in my written testimony, give some examples of how valuable it's been, and I certainly agree with that. I support the Permitting Litigation Efficiency Act precisely because I think we need those kinds of reforms in order to save NEPA. And not so much to save it from itself, but to save it from judicial interpretations that have gradually fed back into the agency process to make it unduly cumbersome. I've submitted for the record a report by an unbiased, nonpartisan NGO, Common Good, called 2 Years, Not 10 Years. And I think it comprehensively lays out the case for why we need the kinds of reforms that are in the legislation. Among other things, it shows that a number of other countries, including Canada and Germany, which are probably greener than we are, do a much better job of permitting and environmental review than we do. And I think that's true for most countries around the world. NEPA is an American invention. It's been a very successful invention. It's been copied in over 200 countries. But as often happens, countries that do something the second or third time are able to learn from the mistakes of their predecessors. And I think we need to go back and make the process more efficient. Now, having said that, NEPA works very well in about 90% of cases. They go through pretty quickly with an environmental assessment that concludes that there are no significant environmental effects. The problem, in my judgment, comes with regard to the larger, more controversial projects which require an environmental impact statement. And unfortunately, I think NEPA has become a way for opponents to oppose projects and delay projects rather than really to improve environmental review, which was not the original purpose. As I state in my written testimony, My experience is that the review of environmental impact statements by the experts at the EPA under Section 309 of the Clean Air Act is what really improves the quality of environmental impact statements, as well as the guidelines set by the Council on Environmental Quality. The costs of undue delay, which are caused by a judicial review, fall into several categories. First of all, as the Common Good Report documents, delaying a project by 6 years typically doubles its cost. And the Common Good Report also documents that delays of public projects, not big business or private projects, but public projects alone, have cost the United States more than $3.7 trillion with a T. And that will be even greater if we go forward with the infrastructure reforms. But the costs are measured not just in money, but also in adverse environmental effects. For example, the decaying electrical infrastructure results in the equivalent of 200 coal-fired power plants. So if you're in favor of improving the environment, you have to be in favor of speeding up environmental review. The third cost, which is more subtle, is that because environmental review takes so long, particularly where there's an environmental impact statement and particularly where there's the opportunities for preliminary injunctions and judicial review, Congress is often tempted, reasonably, to exempt projects from NEPA. There are over 50 examples of where particular projects or even whole programs are exempted from NEPA and therefore get no mandatory environmental review. The culprit is not public participation or environmental review. The culprit is the judicial review process, which has been tacked on to NEPA. There is no judicial review provision in NEPA. My last point is NEPA is really an exception to review under the Administrative Procedure Act. Under the Administrative Procedure Act, and I cite a Supreme Court case to this effect in my written testimony, it is generally not permissible for a single district judge to issue a preliminary injunction against a government agency. That's an exception that was created under NEPA because we didn't realize early on that review was under the Administrative Procedure Act. So I support the reforms in the Permitting Litigation Efficiency Act, and I'd be glad to answer any questions. Thank you, Mr. Chairman.
Thank you. Mr. Kovacs.
Thank you, Mr. Chairman, Ranking Member Cicilline, and members of the committee. A lot of what is in my testimony I think you've already hit, but let me hit a few of the really key points. This committee in 2012, starting with Chairman Goodlatte and then Mr. Marino, were the ones who really started the permitting review process through the RAPID Act. And the discussion at that time, after numerous hearings, was really the debate between the environmental community and the business community. The business community had a point, which is the permitting process takes too long for a lot of what Professor Elliott said, a lot of litigation, infinite reviews of every aspect of a deficiency in an EIS. And the environmentalists were very concerned that we were going to in some way gut NEPA, which was never the concern of the business community. There's no one who believes that it should be done or shouldn't be done. It should be done. And the compromise that came out of this was a bill which did two things which were really, I think, very important and which are the basis for going forward. One is that they recognize that NEPA, the substance of NEPA should stay intact, but if the problems with NEPA were truly structural in the sense that you couldn't get a study out in 2 years or 3 years or 5 years, that what should happen is you leave the substance intact, but you put a structure around it to make sure that the agencies get it done. And that is what FAST 41 did. When we got to the Senate side, a lot of the provisions that were part of the House bill were picked up by both Senators Portman and McCaskill. And two of the provisions that were offensive to the environmental community, the automatic permitting, was taken out, and the statute of limitations was moved, I think, from 150 days to 2 years. But that was still down from 6 years. And that was the essence of the compromise, and that had the environmental community support, and it had the business community support. So in that sense, you had a solid piece of legislation. The difficulty that we have now with FAST 41 And in addition to Fast 41, you have WRDA and MAP 21. So you have highways, covered waterways, and you have large infrastructure projects. There are a lot of other projects in the United States. In fact, OMB, when we were going through Fast 41, only estimated that there were about 200 large projects in the U.S., but you have thousands of projects moving forward at any one time. And that's one of the things that the Permitting Litigation Efficiency Act addresses. So the two issues that are a concern right now, why you need this new law, is one, Fast 41 does expire in 7 years. In 2022, it goes away. And when it goes away, several things are going to happen. One is the structure, which actually gets the agencies to start up front and do the work that's needed, is gone. And the work that's done up front is everyone is brought into the process. The states are brought in, the local communities are brought in. There's a timeline set. There's a continuous monitoring of the projects. There's responsibility in the sense that if you're not going to meet the timeline, something has to be reported to the president. There's a dispute resolution process. So you have the structure there. But the second thing is, in addition to it going away, is it only applies to projects that are $200 million or more. And so what the Permit Litigation and Efficiency Act does, through very simple language, one is it defines what unreasonable delay is, and by defining what unreasonable delay is, it in effect tells the agencies you have to act by, one, the permit time or within 2 years after the application is completed, and two, it then picks up the statute of limitations and makes it uniform throughout the code, which is something that would really be extraordinarily helpful. So with that, I think what you're finding is that Congress has a choice. We can go back, we can let Fast 41 expire, in which case we're going to have no time limits on environmental reviews, and you're back to the same thing. And you're going to have a 6-year statute of limitations, which was never imposed by Congress. It was imposed really by the courts when they decided that there was judicial review. So with that, I think that the Permit Litigation and Efficiency Act is a solid piece of legislation that frames ideas and keeps the process going if Fast 41 goes away, or if the better alternative might be to make Fast 41 permanent and then put in the Permit Litigation Act for the remainder of the smaller projects. Anyway, thank you very much, and I look forward to questions.
Thank you, Professor Hammond.
Thank you, Chairman Marino, Ranking Member Cicilline, and distinguished members of the subcommittee for the opportunity to appear before you again today. Amending a general statute like the Administrative Procedure Act to address a particular perceived problem is guaranteed to cause confusion in the courts, produce unintended consequences, and undermine the rule of law. I'll provide examples in my testimony today. Turning first to plea, the bill suffers from an initial flaw in that its scope is entirely unclear. The bill applies to federally required permits, but does not define those terms. The closest definition is in Section 551(8) of the APA, which provides that a license is a whole or part of an agency permit, certificate, approval, registration, charter, membership, statutory exemption, or other form of permission. The APA does not define permit, so plea creates confusion. Does it include all licenses, some subset of licenses? We don't know. Section 2's presumption of unreasonable delay creates perverse incentives and is unnecessary. The first two subsections, which leave agencies to set schedules or resort to the default 2-year action deadline, creates a perverse incentive for agencies either to forego creating schedules altogether to the detriment of transparency and public engagement, or to schedule final action dates so far into the future as to be meaningless. These provisions are all the more problematic when compared to the cross-references in subsections A, B, and C. Those provisions are subject matter specific statutes that are already aimed at streamlining environmental permitting. They foster transparency. They acknowledge that agencies may lack the resources to complete permit reviews if they're insufficiently funded. They highlight the importance of public participation in the permitting process, and they promote agency coordination as a means of limiting red tape. These cross-referenced provisions are superior to the bill and only highlight the difficulties of using a general statute like the APA to address highly fact-specific permitting issues. Section 2C of plea establishes a one-way ratchet in favor of regulated entities with its special statute of limitations. But even more concerning is the component of 2C that limits judicial review only to matters that were included in the record of proceeding. That's already the law. It has been since 1943 in SEC versus Chenery Corporation, and it is also present in most agency statutory mandates. There are a few rare and necessary exceptions to the Chenery rule that permit supplementing the record only in very narrow but important circumstances. These include cases in which an agency has failed to place all of the information upon which it has relied into the record. This also includes cases where relief, like a preliminary injunction, is at issue. In fact, the limitation in 2C would have the impact of forbidding courts from considering the vast scope of matters required by Section 3. Section 3 is further flawed because its new standards for equitable relief invite a protracted, unmanageable, unpredictable judicial exploration of matters of the general economy. The current standard for equitable relief is sufficiently flexible to permit courts to tailor their considerations to the matters at hand. The bond requirement chills public engagement and has grave federalism implications. Read in conjunction with subsection E, the $5 million bond requirement amounts to a massive fee-shifting provision that expects petitioners to gamble on unpredictable judicial outcomes. This chills more than public interest groups' access to justice. States and local governments frequently have a stake in federal permitting decisions, especially those that implicate land or water use. These governments can no more afford the bond risk than can public interest groups, yet their participation in judicial review protects important federalism ideals. Business competitors are also frequent petitioners before the courts. The bond requirement chills healthy competitive forces as well by weighting the scale in favor of a single permit applicant. The second bill is deficient for many of the same reasons as plea, but in addition, by retroactively changing the rules of engagement for a project that has already reached a full decision, the bill makes a mockery of the public participation that took place already and undermines the democratic legitimacy of the administrative process. I urge you to reject both of these bills, and I look forward to your questions. Thank you.
Thank you. Mr. Rickman.
Chairman Moreno, Ranking Member Cicely, my name is Mike Rickman. I'm the Deputy Director of the North Texas Municipal Water District, and we're located in Wiley, Texas, which is a suburb in the Dallas area. I appreciate the opportunity to testify today in support of H.R. 4423, the North Texas Water Supply Security Act of 2017. This legislation provides much needed limitations on judicial review and decisions and authorizations associated with the lower Bodart Creek Reservoir. The district currently supplies drinking water to over 1.7 million people in the North Texas area and has a service area that covers 2,200 square miles. And to put that in perspective, that's a little bit larger than the state of Delaware. The area has some of the fastest growing cities in the United States, and over the next 50 years, we have water demands that are projected to be 1.5 times what they are today. We have a myriad of water supply reservoirs to meet the demands of this rapidly growing population. However, even with these resources and conservation programs that have been enacted to maximize the existing supplies, the district needs to develop new supplies. This reservoir project is a critical component of the region's long-term supply plan. The reservoir is projected to cover approximately 16,000 acres and will provide 108 million gallons of water per day. The project is the only viable supply that can address the district's immediate water supply needs. It's essential that this water supply come online in 2022 to prevent having a water crisis in the area. To that end, the Corps of Engineers issued a 404 permit that allowed construction to begin on the reservoir. That permit was issued on February 2nd of this year. The 404 permit comes after approximately 15 years of the district's collaboration with federal, state, and local officials to study the proposed reservoir, obtain the necessary state water rights permit, and perform the environmental reviews required under the 404 permitting process. To date, the district has invested more than $164 million toward planning, permitting, engineering, and acquiring the land for the project. Construction of the project commenced earlier this month and is expected to be completed in 2022. Lower Barnett Creek Reservoir is the first reservoir to be permitted and built in Texas in over 30 years. I want to thank Congressman Sam Johnson for introducing H.R. 4423 and for Congressman John Carter, Jeb Hensterling, John Ratcliffe, and Pete Sessions for their co-sponsorship. H.R. 4423 provides a critical protection for the Lower Barnett Creek project. H.R. 4423 limits the judicial review of the 404 permit so this multi-year, $1.6 billion project is not constrained by legal challenges. 4423 accomplishes the goal in 4 ways. First, it limits who may challenge the environmental reviews. There has been numerous public meetings. There has been a draft EIS and a revised draft EIS, which both had public comment periods. So limiting the standing is something that we think is reasonable. The second thing it does, it limits when the suit can be filed. Currently, under the NEPA process, it can be filed 6 years. So that means that we could have the project completed, in service, and operational, and get a legal challenge that would not allow us to use that project. And with public funds being spent, we would continue to make payments on that project without having the ability to use it. Third, 4423 limits where the legal challenges can take place. We think it should be in the Eastern District of Texas, where the reservoir is located. And fourth, it ensures that any federal action for a temporary restraining order and injunction against construction or operation of the project, that the court consider how critical this project is to the residents of North Texas. As you can see, 4423 does not completely circumvent the judicial process. If enacted, it prevents further unnecessary delays in critical water supply projects in the federal courts. Therefore, it's imperative that the critical supply project be reasonably protected from frivolous legal challenges that have the potential to seriously harm the water supply. Thank you for the opportunity to comment. I'd be happy to answer any questions.
Thank you. The chair now recognizes the chairman of the full committee, Chairman Goodlatte, for his questioning.
Thank you, Mr. Chairman. Mr. Kovacs, FAST 41 was bipartisan legislation that you referred to containing good reforms, but it unfortunately has a 7-year sunset. Isn't the legislation before us today, the Permitting Litigation Efficiency Act, generally consistent with the policy goals of FAST 41?
Yes.
And if FAST 41 is allowed to sunset, but this legislation is enacted before it does, will the latter at least assure that a permanent baseline of genuine permit streamlining reform remain in place?
Yes, it would be the default provision.
And if FAST 41 is made permanent, which is my hope, is there any reason to believe that the Permitting Litigation Efficiency Act could not remain in place as a good adjunct to it, providing permit streamlining for projects not covered by FAST 41?
You're correct. They'd actually work together. FAST 41 would take the projects over $200 million, and Permit Litigation Efficiency Act would take the smaller ones.
Mr. Elliott, the Permitting Litigation Efficiency Act doesn't eliminate judicial review of NEPA claims. It just insists that they be brought in a more timely way based on issues presented to the agency. I'd like you to respond to some of the criticisms of Professor Hammond and tell me, isn't it more consistent with the original intent of NEPA because it allows permitting decisions to be made efficiently and better assures that agencies actually are able to consider all of the relevant information during their initial reviews?
Yes, Mr. Chairman, I think it is. I don't believe that it would adversely affect the ability of citizens groups to come in and raise issues during the administrative process in any way. With regard to the bonding requirements, when judges somewhat capriciously stay projects, issue preliminary injunctions, there are real economic costs. I give the example of the Atlantic Sunrise pipeline, which was only stayed by a court for 3 days. But in that 3 days, it put 2,500 people out of work for 3 days and imposed $24 million of costs on the company that was promoting the project. And that's a real economic loss. I believe in that case, it was an administrative stay that was issued by the clerk's office in the DC Circuit without even being looked at by a judge, based on my experience having been a clerk on that court. So I think it's important to make challengers think twice about the real economic harm they have. They could still challenge a NEPA statement. They just don't need to get a preliminary injunction that halts the construction of a pipeline and puts 2,500 people out of work. And this really builds on existing law. Bonding requirements already exist. This simply beefs it up and tries to make it more frequent. I'd go farther. I think that preliminary injunctions and permanent injunctions under NEPA are inappropriate. We don't do that under the Administrative Procedure Act in any other area. And again, as I said in my opening summary, that was really based on a longstanding judicial mistake. Initially, we weren't clear whether or not a judicial review under NEPA was under NEPA, and therefore preliminary injunctions applied, or under the Administrative Procedure Act. It's now clear it's under the Administrative Procedure Act, and we don't allow judges under the Administrative Procedure Act to issue preliminary injunctions in ordinary Administrative Procedure Act cases.
Thank you. Thank you, Mr. Chairman.
Chair recognizes the ranking member, Congressman Cicilline.
Thank you, Mr. Chairman. Thank you again to our witnesses. Professor Elliott, I just want to start with you. You have previously written about something you described as regulatory ossification, a concept that you used to describe agencies that have been burdened by too many requirements, such as inflexible procedural and analytical requirements in the rulemaking process that presumably lead to some unnecessary delay. And so I wonder whether you still have that concern today, that agencies lack the resources, staff, and funding to achieve their statutory missions, and whether or not this inadequate funding and insufficient resources has an impact on the delays that you describe in environmental permitting.
I think all of that is true, but in my view, the primary problem is that these reviews have become too complicated as a result of what I call defensive medicine, or my friend Philip Howard calls leaving no pebble unturned. And what we need to do is to set deadlines that will require agencies to prioritize. There's never going to be enough funding to get into all of the very small details, and the incentives that are created by NEPA and litigation under NEPA are to find some issue, no matter how small, that hasn't been adequately considered, and then use that as a ground to stop a project. I ask my students sometimes, there's a case where...
I don't mean to cut you off, but
okay,
I
I'll
just
stop.
have a limited amount of time. Thank you. I want to, Professor Hammond, I'd ask if you would respond to that. You know, do agencies have the resources they need and the personnel to do the reviews that are required under NEPA?
No, they don't. They are underfunded. And one of the problems with plea is that it doesn't account for that possibility, whereas, for example, FAST 41 does. So again, we see this problem with using a general statute as a very awkward way to get at a specific problem.
And would you, Professor Hammond, speak a little bit about how these bills, particularly the broad sweeping piece of legislation, undermine public participation for federal projects that affect local communities? I served as a mayor of Providence before I came to Congress, and the idea of silencing the voices of local officials in these important projects that have a tremendous impact on the local community is very alarming to me.
This is where I think that the $5 million bond requirement is indeed a terribly scary thing for any local government that might be wanting to participate in the process and see it through. And so So just seeing that number on the paper will chill a number of meritorious claims, and I think that's a significant problem with this bill.
And, one of the things that, I guess part of this is whether or not you believe that public participation and community engagement on these major projects that require federal permitting is a net positive or net negative. The thing that concerns me in particular about the legislation is I think people already have a sense that very often their voices are not heard, that the voices of ordinary citizens are not heard, and the powerful voices of corporate special interests are taking precedence. And I'd like your assessment as to whether or not you think that that makes that more likely or less likely as a result of this proposal.
I think it's more likely to be a problem. There's all kinds of social science research, legal research showing that when people have a voice that is heard, not only do we reach better decisions, but we have greater acceptance of the decisions that are made. That promotes community as well as promoting necessary projects.
And Professor Herman, do you agree that there is a substantial amount of evidence out there that the delays for projects that require federal permits are a result of inadequate funding of agencies, a number of other factors unrelated to the permitting process?
That's correct. There are a number of causes, and underfunding and understaffing is a major one.
And my final question is, this Permitting Litigation Efficiency Act also provides for the automatic award of a litigation bond to the defendant unless the plaintiff's claim was substantially justified. Are you aware of any similar requirements in current law, and do you believe that this is essentially a fee-shifting requirement, which I think you already referenced, but are you aware of any other place that this happens in existing law?
I'm not aware of any, and again, we heard this concern raised about the capriciousness of judges. There is no standard to define what should happen there, and it does look very much like a presumption in favor of fee shifting.
Thank you. I yield back, Mr. Chairman.
Chair now recognizes Congresswoman Handel from Georgia.
Thank you, Mr. Chairman, and thank you to each of our witnesses for being here. I would like to start with Mr. Kovacs, please. I come out of local government, former county commissioner, chairman of that county commission in Fulton County, Georgia, and one of the things that I've seen with the NEPA process is extreme delays of very critical public projects, in addition to extreme delays on private projects, but in particularly public, to the point where in my congressional district, some jurisdictions have literally said, no, we don't even want to participate with the federal government around projects and would rather go it alone. So there was an original intent behind NEPA that the review process would be efficient and that NEPA itself would not contain an authorization of judicial review. Is it fair to say that the Permitting Litigation Efficiency Act, which we're discussing today, rather than somehow undermining NEPA, actually restores the NEPA process and any time consumed by NEPA litigation more closely aligns with the original congressional intent?
Excuse me, I think you're right, because it does two things, and why I think it's consistent is the original congressional intent was just to consider the environmental issues. Through the course of the years, which I think is where the problem has started, is that the courts decided to legislate rather than Congress. And when the courts decided to graft on a private right of action, they decided that instead of looking at all of the large details to find out what the environmental issue was, they decided that everything was a deficiency in the process, and that's what extended it out. Now, when you get into the litigation act that you're considering today, all it says is you're going to do this in a shorter period of time. You're going to do it by the time of the assigned permit date for considering it, or if there's no assigned date, you're going to do it within 2 years. And at that point in time, that's when the litigation starts. So the time limit is really something that federal agencies right now have an obligation to meet. They're not meeting, and there's no consequence. So yes, I agree with you.
One thing that I want to point out is that when local jurisdictions are teeing up various projects, before the funding component of it is even pursued, and the permitting process is even pursued, there is already a long public comment period through the various regional commissions that exist, in my case in Georgia, the Atlanta Regional Commission. So is there anything in this new legislation that, from your perspective, in any way limits what would be done to deciding what a project might be from a public comment standpoint, and then secondly, limiting public comment in regards to the timeline?
Absolutely nothing.
Okay, thank you very much. And with that, I'll yield back, Mr. Chairman.
Chair recognizes the gentleman from Georgia, Congressman Johnson.
Thank you, Mr. Chairman. Gosh, this is a pretty chaotic time that we are in. The Mueller investigation continues to get warmer and warmer. The U.S. Attorney for the Southern District of Georgia has procured and executed a search warrant for the hotel room, home, and offices of President Trump's lawyer. The president sits beleaguered, thinking about pulling the trigger on an effort in Syria, a military effort that could wind up involving the Russians. We've got a brand new national security advisor, the third advisor in this brand new administration. Just took the job on Monday, the same day that the director of the Homeland Security advisor resigned. It just looks like total chaos around here. Now, Mr. Rickman, we have a process that's been in place to ensure that the federal government follows its own environmental laws, but this bill would create an exception for just one project. Do you believe that Congress should be spending its precious time favoring one parochial project over another?
I think Congress should be addressing the issue of what it takes to permit a project of this size and scope, and that once you go through that almost 15 years of permitting, you need something to solidify the process.
I understand that this is an issue of grave importance to you, but there are so many other issues that appear to be of importance that this committee should be looking at, and it's my opinion that we have a lot of things that take precedence and priority over this local issue. But let me move to Professor Elliott, and thank you for your response, Mr. Rickman. Mr. Elliott, you are a published author, 7 books, 70 articles, including one that is entitled Why Punitive Damages Don't Deter Corporate Conduct Effectively. Do you still support the premise of that article that you wrote?
Yes.
And you've spent your entire career defending big corporations, have you not?
Not entirely, no.
Well, you've done some teaching in addition to that, I'll give you that.
I was general counsel of EPA.
And a very corporate-friendly EPA.
I don't know about that. We passed the 1990 Clean Air Act amendments when I was there. I think that the first Bush administration, Bush 41, was really to the left of the Clinton administration.
I tell you, it was certainly to the left of Scott Pruitt, and so
I'm not going to comment on that.
My hat is off to you. Do you believe that a $5 million bond to bring a case will create a perversion of the legal system and make courtrooms available only to the wealthy?
Yes, but of course that's not what this bill does.
Well, that's the effect of this bill.
No, that's not right.
How can it not be right if the legislation that you're here to testify about today gives judges the authority to order a litigant to post up to a $5 million bond before the litigation can proceed, recognizing that we're packing the courts with right-wing corporate-friendly, anti-regulatory judges?
Well, thank you for that question, which I think really goes to the heart of the matter. The bond only applies, as I understand it, if the challenger seeks to enjoin the project. And it would be perfectly,
And of course,
it would be
that
perfect
is
if I may
exactly
finish
what-
my answer.
That's the kind of litigation that we need to protect harms to the public. Now,
But
Professor,
all of these
and my
statements-
time is limited, Professor Elliott. Let me go to
So is
Professor
mine.
Hammond. I understand, but I appreciate you being here too. Professor Hammond, how will this legislation chill the ability of litigants to bring actions to protect the health, safety, and well-being of Americans?
If I may respond, the $5 million bond does give this discretion to judges. It is scary. It will chill litigation. We can expect only those who can afford it to come to court, further marginalizing all of the voices that do have an interest in what happens with these projects.
I thank you, and I'm at the end of my time. I yield back.
Chair now recognizes Congressman Radcliffe from Texas.
Thank you, Mr. Chairman. I'd like to thank all the witnesses for being here today, and I'm grateful for the opportunity to speak in support of the North Texas Water Supply Security Act as one of its original co-sponsors. I want to thank all my North Texas colleagues for all of their hard work and time and effort on this bill over a considerable period of time, specifically its sponsor, Congressman Sam Johnson. And Mr. Chairman, at this point, I'd ask unanimous consent to submit a statement in support of this bill from Congressman Johnson.
Without objection.
I want to start out comments from my friend, Mr. Johnson from Georgia. Mr. Rickman, he talked about the specific project, the Lower Bodark project, and questioned whether or not Congress should be spending its time on a local issue that's just important to you. North Texas Municipal Water District services how many North Texans?
1.7 million.
And without this legislation that we're considering today and the resources that it will allow North Texas Municipal Water District to supply to those 1.7 million, at what point does North Texas Municipal Water District become unable to service 1.7 million Texans?
Currently, the projections are showing in 2021 or 2022 that we would not be able to support the population that is projected to be there.
Well, I would submit that 3 years is not a long period of time, and it's not a trivial matter, and every member of Congress that has time to devote to this issue should do so. So I thank you for being here to speak to this specific issue. With the Lower Bodark Creek, we saw an environmental review process take longer than usual, and that was due essentially to delays in the environmental impact statement having to go through a number of revisions, correct?
That is correct.
What is your opinion on the harm that is caused by delays in the environmental review process on important projects like Lower Bodark?
The issue that you have to address is the timeliness and the cost. The timeliness meaning that the process of going through the environmental impact statement, getting that prepared, submitting it for public comment, and in this case, we had to have a draft EIS and a revised draft EIS, which took over 2 years as a result of a federal agency not liking the type of testing that was taking place in the field, although they had agreed to it up front. The second part of it is the cost associated with that. The delay was a little more than $25 million in cost.
And again, I know you've testified to this, but the permitting process here for the Lower Bodark project has taken 15 years, correct?
The actual permit for the 404 permit was filed in June of 2008, but we had spent several years prior to that working with the federal agencies, getting the application prepared correctly.
And do you think 15 years is an appropriate period of time for people to have the opportunity to raise issues with the permitting agencies for a project like this?
Absolutely. There were numerous public meetings at the state, federal, and local level.
And yet currently, despite 15 years to raise those concerns under the current law, they'd have an additional 6 years to interrupt the project with an injunction or temporary restraining order, correct?
That is correct.
So North Texas Municipal Water District could move forward with this project, get it 95% complete, and someone could theoretically, under the current state of the law, despite having 15 years prior, stop this project and North Texas Municipal Water District's ability to service those 1.7 million Texans relying on that water supply, correct?
That is accurate, and there's no viable option out there to get something to replace this in the short term.
Well, Mr. Rickman, thank you again for speaking on this issue. And again, I'd like to encourage all my colleagues to support this legislation. With that, I yield back.
Chair now recognizes the gentlewoman from Florida, Congresswoman Demmings.
Thank you so much, Mr. Chairman, and thank you to all of our witnesses for being here. Ms. Hammond, I'd like to start with you. What effect will limiting judicial review? We've heard a lot of talk about judicial review actually undermines the original intent of NEPA, but what effect will limiting judicial review have on local economic interests like those of small businesses, in your opinion?
Well, those are the very small businesses that may have an interest in seeking judicial review. And so if it's limited, once again, they can't make their voices heard. This is both in inherent limitations in the way the statute is set up and again in the bond requirement.
You know, I also come from local government, and I do believe that public participation is not only important, but it's necessary. We've talked a bit about it, but let's talk about it a little bit more. Are you concerned that the proposed bill will undermine public participation for federal projects that affect local communities?
Yes, it does do that. I should note, it is already the law that any issues that are raised in litigation must have been raised before an agency. What this bill does is appear to restrict that even further, to cut off the ability to raise further arguments to judges that the agency did not do their job properly, despite comments raised. That final check of judicial review is a key part of not just making sure that agencies exercise their power properly, but giving voice to those who would participate.
Thank you so much, Professor. Mr. Kovacs, you've argued that the major causes of delays in federal permitting is the mandate that conduct environmental reviews under NEPA. Of the many federal actions undertaken every year, about how many require an environmental assessment in the first stage of the NEPA approval process, would you say?
Actually, I've never said that there was, that the mandate to do the environmental impact statement had any harm at all. It should be done. What I have said is that the dispute was over, if the mandate is to stay, then the problem is timing. Then you can put a structure around timing where you get into the public participation requirements, bringing the state and local governments in, but you do it in a coordinated way up front so that you can meet the time deadlines, and that's what fast.
Okay, and roughly how many would you say?
In the course of a year, I'm going to say 50, 60, 70, some. It's not
Not a great number.
Thousands, most of them go either through a categorical exclusion or through an environmental assessment.
So would you say only the largest projects will require that?
Well, that's why that's why Fast 41 was limited to the projects over $200 million, because that seems to be where the bottleneck would come about.
How many of the transportation projects, again, very concerned about local issues, how many of the transportation projects would you say are subject to a full NEPA review?
I can give you the best statistics I have is that when they did map 21, the time for a transportation project based on the map 21, which is different than Fast 41, was cut in half, and that's a DOT study. And then if you look at the Recovery Act, which was the Barrasso Boxer amendment, where they said all projects are to go in the most expeditious route possible. Out of the 192,000 projects, 192,000, only 841 went through a full environmental review. So it gives you an idea. It's a very small percentage.
About 3%, would you say, based on what is,
You're
what a
probably
pretty
better at math
small,
than I am.
small percentage?
It's small. It's not a lot.
Okay, I just have one more question in my less than 50 seconds. You know, these are very important issues, and I know that I want to get it right. It is important to our local communities. Professor Elliott, my colleague who ran out of time, and it just concerns me, when he said that his time was limited, he was referring to the 5 minutes that the chairman gives him, that he has to control. 5 minutes is not much time to ask for witnesses. These are critical questions so we can get it back. So he was referring to that. I know you've done some outstanding work, but I am interested, just for my own personal edification, when you said your time was limited, what exactly were you referring to?
The same thing that he was.
You were concerned about the 5 minutes that he had to control.
Right, the time that I was not allowed to answer his question because his time was expiring.
But you do understand that he controls the time, right?
Yes.
Okay,
Yes,
all
I
right.
do, and
Thank
that's
you, and
why
with that, I yield back,
that's why I
Mr.
shut
Chairman.
up.
Thank you so much.
I think everybody understands the rules here. The chair now recognizes Congressman Buck from Colorado.
Thank you, Mr. Chairman, and I yield to the as much time as the young lady from Florida would like if she has any further questions that she would like to ask.
I appreciate that. I appreciate your willingness to do that, but I'm complete, so thank you very much.
You bet. Are any of you familiar with the Northern Integrated Supply Project in northern Colorado? It doesn't look like it. You are, Mr. Rickman?
I know the name and I'm aware of the project,
Okay.
but I don't know much about it.
Well, it just seems like this is a recurring theme that many members of Congress hear about, and it's a concern really to all of us. There is no profit incentive in government, and there shouldn't be necessarily a profit incentive in government, but we can't allow these issues to drag on and on. There were a dozen communities in northern Colorado, fairly small towns, that got together to develop a water project. They started 20 years ago. 5 acres of land was wetlands, and so the federal government had jurisdiction. The Army Corps of Engineers had jurisdiction. It continued on, and there are 2 projects actually in Colorado. One is the Chatfield Reservoir that was only filled halfway, and they wanted to fill it 2/3 of the way for drinking water for the Denver area. It's been 20 years now since that started. My question to all of you really is, and Mr. Rickman, we can start with you. Do you understand the concern that we have and the need for legislation and what we're trying to do here in Congress? Balance interests, not just take one side of this issue, but really how do we protect the environment at the same time that we try to speed this process up so we don't bankrupt communities that are trying to develop drinking water?
Absolutely, we understand it. The organization we work for, we are an environmental organization. We look at the environment, we protect the environment, but we also understand the need that we cannot predict and cannot control the population coming into our area, and we have to have water there and be available for public health and safety, unlike a highway. A highway, you can have traffic jams, but water is for public health and safety, so it takes much longer to develop.
And Professor Hammond, I guess the critical issue in my mind is in northern Colorado, there are 2 alternatives. One, we can develop water. We send more water out of the state than we are required to based on the compacts that we have. So we can develop water projects, or municipalities, and they have done this, buy farms, take the water off the farms, and let the farms dry up. And that has a huge environmental impact in drying up farms. We end up with dust bowls in areas, and if that continues because of the growing population in Colorado, that has a serious environmental impact. So there is no real good answer here if we don't move this process along more quickly. Your thoughts?
It's absolutely fair to ask agencies to move as expeditiously as possible, provided we also are asking them to do a good job. And it is a difficult thing to balance.
And the agencies don't have unlimited resources. We just can't throw a ton of money at this situation and say, here's another 100 people, go do the job.
That's right, and that's why plea is problematic, because it doesn't recognize that agencies do have those barriers to moving expeditiously and to doing that good job. It slaps a very large Band-Aid on a much more particular problem that is addressed in Fast 41.
Okay. Mr. Kovacs, any thoughts?
Well, whether you're a Republican or a Democrat, I mean, the one thing that for years that I've heard is, I've got this project in my district, and how do we get it to move? And one of the balances that was so important in Fast 41 is that it recognized all the public participation has to come in, but it has to come in a coordinated way and in a time frame so that the agency can do it. Second, by limiting Fast 41 to the $200 million and above projects, or those projects that have multiple agencies involved, it limited to roughly about 200 projects in the country, but they're the largest projects. And it said, we're going to put our resources on these to get these out the door. The reason that the Litigation Act today is so important is that it extends at least the statute of limitations and a definition of what is unreasonable delay to the smaller projects, so that they have some of the benefits of Fast 41, since they can't get all the benefits.
Great. Professor Elliott, just a little time left. Any thoughts?
I think the most important part is setting deadlines, which then sets priorities. It's not just a matter of funding, but setting priorities. And I think it's very important to understand that the bonding requirement applies to seeking an injunction to shut down a project. Doesn't close the courthouse to anyone. They could do it just the way they do in other cases, and that is get a final judicial opinion before they seek to shut down a project.
Great. Well, thank you very much for all of you being here. I appreciate it very much. Yeah, I yield back.
Thank you. I have a couple questions to finish up. Mr. Elliott, I don't think there's anybody in this room that doesn't want clean air and clean water. I live out in the country. I get my water from a well behind my house. Love watching the bear and the deer go through my property in the woods, and to take it very seriously. And everyone should be concerned about our environment. But can you provide me with some examples concerning what the long delays in permitting review can actually end up perpetuating real environmental harm caused by existing infrastructures?
Certainly, Mr. Chairman. I've given a number of examples in my testimony, but as a general matter, new infrastructure is cleaner and more environmentally conscious than the old infrastructure that it replaces. So when we delay new infrastructure by looking unnecessarily at very small issues that really don't go to the environmental benefit of a project, part of the cost of that is the environmental benefit of the project that's deferred. That's a general answer to the question, but there are lots and lots of examples, some of which I've given in my testimony.
I can give an example too. There's a electric coal-fired plant in my district that spent millions of dollars on scrubbing, the exhaust, the whole 9 yards. They switched over to natural gas. It took years. Cost them tens of millions of dollars because of the permitting process. But finally, in about another month, that's going to go online. So there could have been significant cost reductions there if we didn't have to wait for the years and years that it took to get the permitting process through. Mr. Kovacs, in your estimation, you talked about jobs could be created and how fast those jobs would become reality. Could you expand on that a little bit, please?
I'm sorry, could you repeat the question?
Yes, yeah, you talked a little bit early on about jobs and how those jobs are created. Could you expand on that and how soon they would be created?
Sure. If you're building a project in Project No Project, which was the study I think you're probably referring to, if you looked at the number of jobs that would be created by the various projects, it was the 1.1 million jobs just during the construction period. So every project is going to have a job. And the good part about the Litigation Act that you're considering today is that in the history of the United States until Fast 41, when a court was looking to impose an injunction or being asked to impose an injunction, it looked at the benefits of, the environmental benefits, but it never looked at the job benefits. Right now, what would happen is the court would have to look at not only the environmental benefits, but also the impact on jobs within the community.
Okay. Professor Hammond, you talked about your emphasis on access to justice in your written testimony, and I support access to justice. I was a prosecutor for 18 years, so I really know both in the state and the federal system. But what about quick access to water supply or replacement of bridges, roads that we're running into, plants that are housing projects that are going to go up that just take endless amounts of time to getting permit, and then at the last moment when the permit process is almost done, somebody runs in and says, there's an environmental issue in here. Don't you think that those should be brought early on instead of waiting? And I do know that there are groups out there that wait till the last day and then file.
They already must raise environmental issues before the permitting agencies, before those permits can issue, if they plan to also seek consideration of those issues in court. The issue in court is to say that the agency did not do its job, which is something we should ask of our government in addition to asking it to move as quickly as it reasonably can on projects.
But there's a reasonable presumption there before the court, and the agency can address that issue immediately.
I'm sorry, sir?
There's a reasonable, rebuttable presumption that the agency can raise immediately in the court if they feel that there is something that they missed concerning litigation. Don't you agree with me on that? The agency certainly can come in and address that issue immediately without waiting to the end of the period or some environmental agency coming in and saying, well, we have a problem here now.
That's right. That's why we already ask people to raise the issues there before the agency.
That's
Sometimes
what I
the
would like.
agency
That's
doesn't
what I
do
would
it.
like to see. If there are environmental issues, let's raise them early on so we can address it. And I know you have an issue about the $5 million bond, but then again, that's discretionary. That's up to the court, correct?
It is discretionary, but it's certainly a large and chilling number.
Well, the judge can not impose that at all or lower that significantly, correct? I've clerked for federal courts.
One can make that argument, but one certainly has to be fearful of the risk that they're taking with the capriciousness of a particular judge in a given situation. And I should note, this is for injunctions because you can't put the environment back.
Yeah. But also, how about the capriciousness of a judge that just simply says, looks at, okay, I'm going to grant this injunction and we're going to slow this project down. So, you can make that argument, I can make this argument. We certainly want our environment to be clean, and I'm right out there with everybody on that, but we have to get these permits done to create jobs. Thank you very much. I appreciate you all being here. I just have to clean something up here for the record. Without objection, the following items will be made a part of the record. A letter of support by the U.S. Chamber of Commerce for the Permitting Litigation Efficiency Act of 2018 and the administration's new interagency memorandum of understanding on permitting, which sets a goal of 2 years for completion of permit review for major infrastructure projects.
Mr. Chairman?
Yes. Yes.
Thank you for that recognition. I'm asking unanimous consent to insert into the record a letter from several groups, including the American Association of Justice, the Center for Biological Diversity, Center for Justice and Democracy, Earth Justice, and several others that could not be with us today, but certainly have grave concerns about the legislation we are discussing today.
Yes. Without objection, all the above requests will be entered as part of the record.
Thank you.
This concludes our hearing. I want to thank all the witnesses for being here. I'm speaking for all of us. I know we learn from you when you take the time to travel here and have discussion with us. I know I personally learn a great deal every time I leave one of these, one of our hearings and other hearings that I sit in. And you always have My door is always open. You always have the invitation to come and visit, to send me information that you would like to have, and so we understand all points in these issues. I was involved some time ago in trying to get a bypass put in my district, which was on the board for 60 years for a myriad of reasons. But the first thing I did was get everybody in the same room, the feds, the states, and the locals, and I asked them, did you ever meet before to sort out these issues? They said no. Construction started a couple of years ago, thousands of jobs, and in 8 years, there's going to be a completion of some beautiful highway that is going to be safer for our drivers and create more business for the establishing stores that are in operation around it for people to get in and out. I know when my wife says to me, let's go down to the mall, I said, no, I got to go through all that traffic. Please don't make me do that. But this will make it more efficient. So we are adjourned, and thank you all very much for being here.